To continue our discussion about the UCC and contracts for the sale of goods and how these differ from common law contracts, we're going to go back to the offer and acceptance and continue talking about those a little bit and explore more how they differ from contracts for services and the common law rules. And then in this video, we'll talk about a couple of other rules specific to the UCC that apply to merchants, people who regularly deal in the business at issue with the given contract. So first, let's go back to the offer. We saw in the earlier video how the rules under the UCC for an offer are essentially a little bit more lenient. You can make an offer that can be accepted even though some of its terms are, parts of the offer are indefinite or terms are missing or some terms are even ambiguous. As long as there's enough of a basis to know what we're contracting for and the parties have both expressed an intention to contract with each other, then we will hold them to it even if some of those terms weren't completely spelled out in the offer, which again is different from the common law rule. For services, you would have to have all these rules spelled out. You couldn't leave the price not mentioned. It would have to be stated exactly what it was that you were expecting to receive for those services. There's another rule under the UCC dealing with the offer, which is specific to merchants, and this is called the Merchant's Firm Offer Rule. We talked about when an offer can be terminated in the previous chapter. It could be terminated when there's a counteroffer, when somebody, the offerer or the offeree, accepts the offer but adds a condition to it. That's considered a counteroffer and thus terminates the original offer. But the original offer can also be terminated by revocation. When you make an offer, the general rule is that you can revoke it any time before the person has accepted it. There's some exceptions to that. One is our option contracts, but generally the rule is that you can revoke it any time, even if the offer otherwise purported to remain open for a certain period of time. If it hasn't been accepted, then you can revoke it. The common law has a rule specific to merchants that prevents them from revoking an offer if they've given assurances that it will remain open for a certain time in a signed writing. Then the UCC treats the offer as irrevocable for that time period. If no specific time period is stated, then the UCC has a rule for that and says it must stay open for a reasonable time, and what that is will depend on the context and circumstances and maybe the custom in that industry and the particular goods that we're dealing with. But in any event, it says that offer will not remain open for any more than 3 months. So if it's stated in a signed writing by a merchant that you're going to keep it open for 14 days, then you must keep it open for 14 days. It's irrevocable. And if that person wants to accept it, they're free to do that, and the court will enforce the contract. And if you give assurances that it's going to stay open for just a reasonable time, but without stating a specific time, then the UCC will determine what a reasonable time is, but in any event, it can't exceed 3 months. Now, the acceptance, we talked about this rule already, but we left one part out, which is what we do after the fact. So with the acceptance, under the common law rules, you can't accept an offer while adding a new condition. So if I say, I want you to wash my car, and I'll pay you $50. If you accept it and say, okay, I'll wash your car for $50, but I want you to throw in something else, your bicycle or whatever. It could be anything that would be considered consideration. Then that now terminates the original offer, and that purported acceptance is actually a counteroffer. That has to be the offerer, the original offerer, now has to decide if they want to accept. So under the UCC, that's different. You can add a condition to the acceptance, and we will still have a valid contract if, in addition besides the condition, you accepted the basic terms that were originally offered. But what we didn't talk about in the last video was what happens to that extra condition. We know that we have, or that extra term, we know that we have a valid contract, but does that additional term that was put in there by the person accepting, does that now become part of the contract or not? And the UCC gives us a rule for dealing with that essentially turns on the nature of the condition, whether it's something that would cause undue hardship or surprise to the original offerer, or is it something that's relatively trivial that wouldn't have a substantial impact on the overall agreement? Now, within this concept, textbooks a lot of times will talk about something called the battle of the forms, and this is describing essentially the context in which this will arise and why it's important with goods contracts. And again, because the rules are a little bit more lenient here, because goods contracts are going to be, for the most part, processed a lot more swiftly. You don't have time to have a long, drawn-out negotiation when you have to replace goods on the shelves. You need them as soon as possible. And so what happens is the person who needs the goods sends the request. They might have their own form that describes the request and what they're asking for, and ask for it to be quickly signed and sent back to them. But the person or the business selling the goods probably has their own form. And just as a side note, with all contracts, you're never going to see a contract really that says this is a contract at the top of it. They're always going to be called something else. It's going to be called a liability waiver, a purchase order agreement. No one ever really likes to say this is a contract, because they always are going to choose other language that sounds is either more descriptive or it's just more palatable for whatever reason. So, I send my sales agreement and they say, okay, they sign that and they send it back. But then they send you a purchase order agreement that they use all the time, and it has their boilerplate language that their attorneys chose that are unilaterally beneficial to them, and your sales agreement is probably unilaterally beneficial to you. And so both of these are exchanged, and also the parties who are managing the acquisition of the goods, they may not be somebody even who's that high up in the company. So they may not have they may not be too worried about reading these, what are essentially contracts, no matter what they're called, or not essentially, they are contracts, whether you call them a purchase agreement or sales agreement. And so their incentive at work is going to be just to complete the deal. Their job may be judged more on how quickly they get the goods to the business or back in the business when they're missing inventory or whatever the situation may be. So these forms are going to be exchanged and often not read. And this is true about contracts in general. But it's very important to understand, because this is why we'll end up with an acceptance, whatever the form that was sent back to the offerer to evidence their willingness to accept the contract. It's going to have different terms in it because they were drafted for different companies. And so it's important with that second form, as it comes back, with the additional terms that are in there, with goods contracts, we know that does not stop the contract from forming. But what happens? Do they become part of the contract or do they not? So the answer to that turns on what the UCC describes as the material alteration rule. And the question is, in the acceptance, those additional terms, are they considered material alterations in the contract, which means they would cause undue hardship or surprise to the person who made the original offer. Some examples of these you can see here are changes to the price, to the quantity, to the item, to the type of item itself, how many of the goods you're asking for. Shifting liability would clearly cause some surprise and hardship to the offer. These are all material alterations that, even though we will form a contract, if a dispute turns on these additional terms, if they're considered material alterations, then the court will not enforce them. They won't be considered part of the final contract. But other than that, both forms will form together one part of the contract, minus material alterations contained in the acceptance. So I'll give you an example here. We'll look at a case briefly. It's called Oracle Industries versus Array Connector Corporation. And what you have here is a New York company and a Florida company. And the clause at issue here is a boilerplate clause that you're going to have in most contracts. It's called a forum selection clause. You'll also see within those, or sometimes next to it as a separate clause, something called a choice of law clause. And these are important for businesses that are doing business in different jurisdictions, and especially around the world. what law is going to apply if there's a dispute. Is New York law going to apply if I'm dealing with a Florida company? If I'm dealing with a Japanese company, it's probably even more important. Is American law going to apply? Is Japanese law going to apply? So you put in the contract a choice of law clause that says the parties agree that this law will apply in this jurisdiction, and then the forum selection clause describes where lawsuits will have to be brought, what forum or what court jurisdiction you'll have to bring the case. And so this is going to be a big deal if you have a dispute and you find out that the forum selection clause says you must bring the lawsuit in Florida, and you're based in New York. Everyone's going to have to you're going to have to bear the cost of if that clause is enforced, of flying everybody to Florida potentially for depositions and all the other expense of litigating far away. So Oracle is a New York-based company who bought airplane-related products from Array Connector Corporation, which is a Florida company. Just like I described with the Battle of the Forms issue, Oracle would send their purchase order forms, and Array would confirm their orders with something they called a customer acknowledgement form. Again, neither of them are labeled as a contract, but that is what they both are. They each contain their own forum selection clause. Not surprisingly, Array's said you have to bring suit in Florida, and Oracle said you have to bring suit in New York. Now, Array is sending the customer order acknowledgement. That's the acceptance. That's the one that's coming second. And so they have a term in there, if they have a different forum selection clause, that is in addition to what is contained in Oracle's. And right, so the clause stated in cases of dispute, Oracle would have to bring suit in a Florida court, and Oracle never objected to the clause. Now this brings me to a point that I skipped. With this rule, the additional terms in the acceptance won't become part of the contract, whether the material alterations or not, if you reject them. So if you get the customer acknowledgement form or whatever it's called, and you call them back and you say, well, we can't sign this because you have additional terms that we don't agree to, then it's not an issue. As long as you reject it, then we don't have this, we're not going to have a battle of the forms. But that's a lot of times not what happens. The battle is between the forms because the people who are exchanging them aren't really possibly even reading them. So they're not making that call to say, we don't agree with this. They're just trying to get the deal done. So Oracle didn't object to the clause, and later Oracle sued Array in New York, which is where they're based, for breach of contract. Now, we don't know from these facts, I don't think exactly what the breach dispute was about, but it is a breach of contract, and the issue here is where do they have to go to sue. And so Array made a motion to dismiss it immediately because they said it's the wrong jurisdiction. We aren't based in New York, so New York doesn't have jurisdiction. But they have this agreement that says, where both of them say that the forum is going to be in their state of incorporation. So the trial court agreed with Oracle, and the case was dismissed, and they said Oracle would have to sue Array in Florida, which again, the Florida clause was in the second form, the response or the acceptance. So this is a new condition, a new term in our acceptance. The appeals court reversed, and basically the trial court just didn't seem to know what the material alteration rule was, because the appellate court said no, additional terms in the acceptance under the UCC don't become part of the contract. Even though the contract is still formed, the additional terms don't become part of the contract they do become part of the contract unless they are considered material alterations. A forum selection clause that shifts the place where litigation is going to happen from New York to Florida is considered a material alteration, because obviously that caused hardship and surprise to the offerer, in this case Oracle. So the second forum selection clause was not considered part of the contract. Okay, another rule in the UCC concerns modifications of contracts. You have a contract, and then you decide you want to modify the terms. We didn't talk about this really specifically in the first chapter, but basically under the common law, if you want to modify the contract, you're going to have a new contract if the terms are modified, and thus you need new consideration because you have to have those terms. You can have an offer and an acceptance, but you still have to have consideration. So you make an offer to modify, it's accepted, but there has to be something exchanged between the parties to bind the offer and acceptance together. The UCC changes that rule and says that you can modify your contract for goods without having new consideration. So you don't have to have something new that's exchanged to modify it. And that's pretty much it. And one other note, though, is that going back to the statute of frauds, if in many cases your contract needs to be in writing to be enforceable, because the statute of frauds, one of the contracts that it states must be in writing are contracts for the sale of goods of $500 or more. So that being said, your modification would have to be in writing as well to be enforceable if the sale was large enough, because that's what the statute of frauds calls for. Okay, one last rule here about merchants failing to respond to a writing and when it forms the basis of a contract. The UCC Article 2, Section 201, Paragraph 2 says, that you can see it there, between merchants, if within a reasonable time a writing and confirmation of the contract and sufficient against the sender is received and the party receiving it has reason to know its contents, it satisfies the writing requirements against that party unless a written notice of objection to its contents is given within 10 days after it is received. What this means is you've had a discussion about a deal that you're going to make, and you're both merchants, you're both people who deal regularly in this type of business. If one of them sends the other guy a writing that describes the deal, and it's signed by that party, then if you don't object to it, even though you didn't expressly manifest some assent in writing, then you will be held to have agreed to it implicitly, and you will be bound to it again unless you send written notice of objection. So it's an incentive to not be silent if somebody says, "Here's the deal that we agreed to. I'm just writing to confirm what we understood." If it doesn't evidence what you think the deal is, then you need to respond and object to it. Otherwise, it could end up being enforced against you. And this is a little different than the way the statute of frauds normally works, because normally it's the party that you're going to enforce it against is the one who has to sign it for it to be enforced. So this changes that. And again, because we're talking about merchants, we expect people to operate with a little greater level of sophistication in their own field. We're going to end it there, and in the next video we'll come back to the UCC and the parole evidence rule and how we apply it to these contracts.